Well, welcome our audience in person and our online audience. And my name is Julie Snyder. I'm president of the World Affairs Council of Western North Carolina, the leading global affairs organization in our region. And I'd like to recognize some of my fellow board members who are here tonight, George Peary and Mark Gibney too. And who else is here? Larry?
And John.
And John. Okay, great. So our council is a member of the World Affairs Councils of America, based in Washington, D.C., and we're one of 92 councils around the country. We're a nonprofit, nonpartisan organization with a mission to educate, inspire, and engage the community in international affairs and critical global issues. And we're a 501c3 charitable organization, and we welcome donations of any amount. And those donations help us cover our ongoing expenses, and we're all volunteer. So, if you've already donated, thank you very much. We're grateful for your generosity, and we're also grateful for our partnership with Ollie, and Ollie provides this room, this lovely room, and our wonderful student technicians, and helps us publicize our events in the Ollie Observer. If you're not on my email list and you'd like to be added, please see me after the presentation, or after the event rather. And if you're online, please put your email address in the chat room and I'll pick it up. We'll have time for a Q&A at the end of the presentation, so please save your questions and comments. And if you're participating online, please put your questions and comments in the chat. So with that, I'll introduce our distinguished speaker of the evening, Mark Gibney, who is the Belk Distinguished Professor at the University of North Carolina, Asheville, and an affiliated scholar at the Raoul Wallenberg Institute in Lund, Sweden. In 2025, he was appointed as the Fulbright Distinguished Chair in Law at the University of Trento in Italy. From 2014 to 2016, he served as the inaugural Raoul Wallenberg Visiting Professor of Human Rights and Humanitarian Law at the Faculty of Law, Lund University, and the Raoul Wallenberg Institute. And so with that, Mark, I'll hand the podium over to you.
Thank you so much, Julie, and thank you everyone for coming here. I've been confined to this penalty box over here because of the thing, and so if I get out of line, if I get out of between the lines, just tell me. So what I'm going to talk to you about tonight is what keeps me awake at 3 o'clock in the morning. All right, these are the kind of things, why we have all this human rights law. We have all this human rights law, and yet we still seem to have massive levels of human rights violations. And so if this keeps me up at 3 o'clock in the morning, then I'm hoping it keeps you up after this at 3 o'clock in the morning as well. So let me tell you, I'm going to begin with what I'm not going to talk about. And this may be of some disappointment to some, but yes, international human rights law, not international humanitarian law. So the difference here is that international humanitarian law, the laws of war, is separate and distinct. I mean, there's a very close connection between the two, but they are separate and distinct. And I think particularly with this invasion of Iran, then you would think, but I'll say one or two things about the laws of war, which is essentially that, oh, this didn't move, did it? I'm thinking it did. Yeah, okay. So just in terms of international humanitarian law, there's jus ad bellum, which is the lawfulness of going to war in the first place. But under international law, there's only two instances where a country can invade another country. One is with Security Council approval, and the second one is in self-defense. So if you have a question, is the invasion of Iran lawful? The answer is no. The second is jus in bello, which is the means of fighting. All right, so the war, you've already entered into a war, and now it's a separate law in terms of how you fight. you could see the Red Cross, you know, their manual on that. It comes down really to two principles. One is the principle of distinction between combatants and non-combatants, and the second one is proportionality. So those are the two things, and we'll see what happens with this American invasion in Iran. But if you're thinking of, give me an example of that, let's take the war in Gaza. Proportionality, distinction between combatants and non-combatants? I don't think so. So let's move on. I'm going to go really quite quickly at the beginning. All right, just to give you background that before the end of World War II, human beings did not have human rights. However your government treated you was not the concern of the international community. So the major change that happens after World War II is that people are recognized as having human rights. And so what I have here is just some of the activity. Now, no one in this room is old enough to remember this, because no one in this room would be old enough to have lived through World War II. Is that correct? Yeah, no, that's right. Okay. And so what you have here is you have a rash of things. You have the UN Charter, you have the Nuremberg trials, you have what's called the International Bill of Rights, which comprises of the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. So what we have here with the parentheses is when the United States signed one of these treaties. You know, there's a two-step process. First, the country signs a treaty, and then they have to ratify it. And the ratification, as you know, being constitutional scholars, is by a vote of 2/3 of the U.S. Senate. Okay, so in some cases, the United States hasn't signed at all. In some cases, they've signed and not ratified. Then we have, in addition to the Bill of Rights here, all these major international treaties. Right? We're not going to go through any of these, but the point I would make about them all is that the approach here was that human rights is a collective effort. Right? And I use the example that if a country, let's take the Torture Convention. If a country wanted to eliminate torture domestically, there's no reason to sign an international treaty. You could do that by domestic legislation. You could pass a law that simply said in state A, torture is prohibited. The reason you have international treaties is that you see the elimination of certain practices as something that is an international undertaking. And in many ways, that is the thesis of what I'll be talking about tonight. That part has been lost, I think. That part has been lost. So you have these international treaties. You have, again, parentheses, when the United States signed and then ratified. In some cases, they haven't done anything at all. And then you have, well, what are we talking about with human rights? Well, this comes from the Universal Declaration of Human Rights. It's a nice list, right? But the only thing I think I would add would be the right to a safe and healthy environment. But it's a nice list, right? It's both economic, social, and cultural rights, which most Americans are not familiar with because of our Constitution, but it also has civil and political rights, which we are familiar with because they're enshrined in the U.S. Constitution. They'll also have this entire body of offices in the United Nations here. You get the High Commissioner for Human Rights, UN treaty bodies that monitor each of those treaties we just saw in the previous slide, special rapporteurs, Security Council, and so on and so forth here. And I'll talk more about some of these later on here. But again, I'm just trying to give you the background here. In addition to the international offices, you have regional offices. In some respects, these are more successful than international. So you have the European Court of Human Rights that comprises 46 countries, and the ECTHR, which is the European Court of Human Rights. You have the American Convention on Human Rights, 24 countries, United States signed but never ratified, the African Charter of Human and People's Rights, 54 countries, but also in terms of human rights protection, a lot of domestic courts. I mean, the domestic courts, I think, particularly in terms of climate change, it's been domestic courts that have been at the forefront. And I just mentioned one of these, this Urgenda case, where the Dutch Supreme Court ordered the Dutch government to reduce its greenhouse gas emissions by 45%, and the political actors in Holland are undergoing that, right? So it's international, regional, and domestic. So then the question I ask is, well, what do we have to show for all this? And I think it's disappointing. In fact, it's quite disappointing. And I'm going to just go through 4 things here. But then I'm going to get to why we're not doing better, right? That's the part I think that I want to. So this won't be any surprise to you. So we'll look at civilian war deaths. And this is before 2025, and this is before the higher numbers in terms of Gaza here. But you get tens of thousands of civilian deaths. Okay, and if you added 25, I think that number would be considerably higher than 48,000. You have displacement here. This is people who are displaced by persecution, by fleeing from violence here. And you can see sort of this marked rise from, I would say, 2012 until the present time. And then one more here, just certain categories. So at the present time, there are 117.3 million people who are fleeing from violence. And of that number, 42 million are refugees. These are people who have a well-founded fear of persecution, and they're outside their country of nationality. That number is dwarfed by the number of internally displaced persons, IDPs, which is 67.8 million. These are people in a refugee-like situation, again, having a well-founded fear of persecution, but for whatever reason, they have not crossed that national border, right? They haven't left their home country and gone to another country. And then finally, you have a little bit more than 8.42 million asylum seekers. I just thought I'd throw this in because, you know, those of us living in the global north think of that we have this, we can't take in any more refugees, we've done our part. Well, the truth is that most refugees are not being housed in the global north, right? This says what, almost 71% are in low and middle income countries. That's not going to say that people in the global north aren't going to continue to say that, but the reality is that they're not part of the problem perhaps, but they certainly have not been a big part of the solution here either. And I thought, let me make an advertisement for the political science department in UNC Asheville, that we produce here what is the oldest and most widely used human rights data set in the world. And I've been doing this from 1984, and it's called the Political Terror Scale. And this is before terror was associated with terrorism. The Political Terror Scale is state terror, right? The extent to which the state makes war on its own citizens, and essentially is made up of political imprisonment, summary executions, disappearances, and torture. Really, those 4 things. And what we do is we have undergraduates who we exploit. Excuse me, I didn't mean to use that word. That we have undergraduates who work coding, and we look at 3 different sources. We look at the U.S. State Department, we look at the Amnesty International annual report, and then the annual report of Human Rights Watch. And they score countries on a scale of 1 to 5. 5 would be North Korea, Sudan, and places like that. 1 would be Switzerland, Canada, places like that. So this is what we came. I just thought I'd show you from the State Department reports from 2004. There's both good news and bad news here. The good news, I guess, is that there's 110 countries that are either at a level 1 or level 2, where there's pretty much the protection of human rights. On the other hand, that we have, I think it's 87 countries that have serious human rights violations. I mean, a typical country in a level 3 country would be pretty systematic torture. You go down to the police station, you're going to be tortured, right? That's almost, torture is by far the most common of those four things I mentioned. A level 4 country, there'd be hundreds of people, if not thousands of people dead, and level 5 countries would be mass slaughter. And there's still a lot of countries here that have very bad human rights records here. And then finally, the last thing here I'll mention is torture. You know, a lot of countries are, to use the lingo here, they're state parties to the Torture Convention, which means that they've signed it and ratified it. Has it changed their behavior? Do they no longer torture? I think you know the answer to that is no, that doesn't seem like it's changed their behavior whatsoever. So of the 174 state parties to the Torture Convention, 140 countries still carry out torture. Most of them are state parties to the Torture Convention. And then a friend of mine came up with this term, double victimization. All right, the first victimization is let's say the torture itself, the initial violation. The second violation is the denial of any form of effective remedy, because every human rights treaty promises that there will be an effective remedy if there is a violation. So what's the problem here? This is, again, at 3 o'clock in the morning, I'm kind of going through, what is the problem, seems to be? Well, I think part of the problem is international law itself. Part of the problem, I think, is states' interpretation of international law, and I can't tell which is which. I think part of it is that there's no place for people to go. If you're tortured, where do you go? Right? If I'm tortured in Paraguay, where do I go? Do I file a claim against the Paraguayan government? I don't think so. Where can I go? Right? That, to my mind, has been one of the continuing problems, is that victims have no place to go. But I also think that what we have is I was going to give that line from Cool Hand Luke, what we have here is a failure to communicate, but I think what we do have is a failure of imagination. So I'm going to go through, this is sort of now getting to more of what I want to talk about tonight, some of the shortcomings of international law. Some of the shortcomings of international law: state responsibility, jurisdiction, foreign sovereign immunity, head of state immunity, the Alien Tort Statute. I'm throwing the ICE because I figured you'd be interested in ICE and why ICE can get away with why it does what it does. One of the quirks of American law. The thing I'm not going to talk about, which I think is a lecture unto itself, is the UN Security Council, which I think has been a disaster. I mean, think of it. You have 5 permanent members. You have one of them that supported Syria for years and now has invaded the Ukraine. You have another one of them that has protected Israel with vetoes and is now making war with Iran. You have China, which protects Sudan. I mean, it's like the worst warmongers in the world are well, not France and Great Britain. Something's got to be done, because I think the system we have here, but I'm not going to talk about that. I promise that. So we're going to do a little quiz here. We're going to do a little exercise here. So we're going to begin with the notion of state responsibility, and my students they know the answer to this thing, so they're not to engage in this thing. So we have 2 situations here. We have state A and state B. State B tortures, state A does not torture. You got that? State A does not torture, state B tortures, okay? Now I'm going to walk you through a number of scenarios. The question here is, has A committed an internationally wrongful act? Okay? B has, because B's torturing. You with me on this? So A does. So what does A do? Well, number 1 here, agents of state A train agents of state B in the art of torture. All right, and keep a mental note here of whether you think the state A has committed an internationally wrongful act. Okay, keep in your mind, when do I think that A has committed an internationally wrongful act? All right, so the first one, they train torturers in state B. The second one is they send torture equipment. In the 1980s, the United States was sending cattle prods to certain Central American countries. The third one is they provide intelligence to State B, which uses the intelligence to carry out torture. You still with me? Okay. Number 4 is that torturers from A are present in State A, but State A makes no effort to either prosecute or extradite them. Okay? We're still doing okay? We're still doing okay. Number 5 here is that torture victims from B are seeking entry into State A to apply for asylum, but State A turns them away, either by visa restrictions or like the United States did with Haitians, which is to go out on the high seas and prevent them from coming, okay? Let's see, that was 5. So number 6 here, you have State A grants refugee status to this guy T, who then goes to State A and attempts to sue State B. All right, so a guy from State B, we'll call this guy T, he comes to A and he attempts to bring a suit against the country that has tortured him. And the case is dismissed on the basis of foreign sovereign immunity. And then finally, and perhaps exhaustively here, my apologies, but State A does grant refugee status to T, who petitions for the government of State A to file an interstate complaint. So the Torture Convention allows what's called an interstate complaint. One state can say, hey, this other state party tortures people, right? They do that. Okay, so here's the quiz here. Here's the quiz. How many of you would say, hey, I think State A has, in every one of these episodes, has committed an internationally wrongful act? Let's see you say, come on, we throw up your hands here. Come on now, humor me. Yes, A has committed an internationally wrongful act. You with me on this one? Has committed an internationally wrongful act. The students are allowed to vote here too. You know that. You know that. How many say, I don't think A has committed an internationally wrongful act at all? I don't think A has committed an internationally wrongful act at all. Nobody? Nobody. Do you want to know the right answer? The answer under international law, the only one of these examples here, there's one. Take a guess? We'll do this like The Price is Right. You know, you'll yell numbers out indiscriminately. Number 4. Number 4 is the only case where I believe under existing international law, the state has committed an internationally wrongful act. I think this is a problem. Right? I think that this is a problem. I think it's a problem in terms of how states see their obligations under international law. We normally would just consider State A, to be a country that meets its human rights obligations. On one level, they don't torture, but they are deeply implicated in the torture by State B, are they not? And yet, under international law, it's not so clear, except for number 4, that they have done anything unlawful under international law. So what I say here is that it should be obvious that states have taken a very parochial, very narrow interpretation of their obligations under international law. Right? They see their obligations as very much territorial. Now remember, in number 4, that was the only time that there were people from State B that were on the territory of State A. Everything else was done in State B. The training happened in State B. The intelligence for torture carried out and all this kind of stuff. The only time that we got away from that was when torturers were within the territory of State A. And under the Torture Convention, there's a provision that a state has to either prosecute or extradite any alleged torturers that are found within its territory. It Doesn't matter if the torture didn't happen in that state. Doesn't matter if the victim was not a citizen of that state. It doesn't matter if the torturer was a citizen of that state. And that's why I'm saying of those scenarios, the only one that I believe under existing international law that A, has committed an internationally wrongful act was because they didn't either prosecute or extradite. But things are changing. I mean, and listen, you don't win many in terms of the human rights field, but one of the wins, I thought, was the so-called Arms Trade Treaty of 2014. The Arms Trade Treaty made it, this is a treaty that essentially said that you're not to sell weapons to countries that violate human rights, okay? You may think, well, geez, that seems self-evident, right? It seems self-evident that you wouldn't sell weapons to a country that's engaged in genocide or massive violations of human rights. Yeah, it may sound may sound intuitive, but not until 2015 did we have an international treaty to that effect. And even then, we have all these state parties, 116 state parties and 26 other countries that have signed, but the big kahuna here is the United States, right? 41, almost 42% of the arms sales are by the Americans. And then their record here is what you have. They sign and then they unsign and then they withdraw and all this kind of stuff here. The other major arms dealer is Russia, which also is not a state party to it. So, yeah, so we may have the Paraguays and Uruguays and Tanzanias of the world that are state parties, but the big dogs here, the countries that engage in the most arms sales, have not been a state party. But again, we're trying to be positive here, right? We're trying to be positive here. This, to my mind, is a positive feature because it's recognizing, and again, it seems self-evident, but it's recognizing that when you're selling weapons to a country that is committing gross and systematic human rights violations, there's something fundamentally wrong with that, and it should be made illegal. Okay, and it should be. And again, the advance here is in 2015. A few other examples here. I think the Pinochet case was one of the shining moments in terms of human rights. Just to take you back to this thing, you had this former Chilean dictator who's out of office after 1990, but he's still head of the armed services. He takes a trip to Great Britain. He's friends with Margaret Thatcher. He goes shopping there. He's getting back surgery, all this kind of stuff. And then there's a Spanish judge, Baltasar Garzón, who petitions for his arrest and extradition to Spain. Now think of how different the world is here. Chilean, I would do this like on a map. You have a Chilean former dictator from Chile who's in the UK, right? Who's being sought to be extradited to Spain to face charges for his violations as the dictator in Chile. But the thing is, it's not just the Spaniards here. This was an absolute international effort. The number of countries involved in this. I must confess to a certain degree of naivete, because I thought this would change everything. I thought that after this case, every single person who had either tortured or had directed torture to be carried out would now be fair game, right? To my mind, the Pinochet case would change everything. I'm still waiting for that. I'm still waiting for that because it has not happened. I mean, there was, and again, you recall with Pinochet, it was on humanitarian grounds. He's a tired old man. He's confused. He doesn't know where he is and all that. Jack Straw, the Home Secretary, allows him to go back to Chile. And suddenly, when he landed on the tarmac in Santiago, he was like my Aunt Pat at a wedding. She throws away the crutches and she's out on the dance floor and he's boogieing in Santiago. Yes, he certainly hoodwinked the British government there. But there's better news here. So we have the second case I have here is the Belgium versus Senegal. And Belgium versus Senegal was odd. I'm fascinated by Belgium for reasons that may be evident later. But Belgium has, so Senegal had the former dictator from Chad. For some reason, it's easier for me if I can almost visualize this on a map. So the former dictator from Chad, which is on the eastern part of Africa, has been granted asylum in Senegal, which is on the west coast of Africa, and the Belgian government brought an action against Senegal saying that they have given asylum to a person who's directed torture, and that Senegal has a legal obligation, you should know it by now, to either prosecute or extradite. The Senegalese government said, well, what does this have to do with Belgium? We didn't, of course he didn't torture. That's always answer number one. They never tortured. But the second thing is we never tortured a Belgian citizen. And the International Court of Justice said, doesn't matter. Belgium is a state party to the Torture Convention, and Belgium is working to ensure that Senegal also meets its obligations under the Torture Convention. Okay. But three more recent examples I think are almost more important. So we have the Genocide Convention. So the Genocide Convention, 1948, this is Article 1, right? The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and to punish. That's it. That's Article 1. So the obligation here is to prevent. Well, what does to prevent mean? Well, in 2007, in the case called the genocide case, the International Court of Justice essentially said each of the state parties has to do everything in its power to prevent genocide. Everything in its power, even if it means they're not going to be successful, even if other states are not meeting their obligations, they have to do everything in their power. So what happens after 2007? Nothing. But then in 2019, you have the Gambia on the west coast of Africa. Again, I'm doing it with my hand here. On the west coast of Africa, which files a case against Myanmar, which is literally thousands and thousands away. Myanmar's answer is, well, what the hell does this have to do with Gambia? We don't commit genocide. Again, that's always the first answer. B, well, they're not like refugees from Myanmar that are flowing into Gambia. Nothing like that. Dismissed the case, and the International Court of Justice said no. Gambia is a state party to the Genocide Convention, and under the Genocide Convention, they have an obligation to prevent genocide. Proceed with the case. And they give some provisional measures. More recently, with South Africa and Israel, in late 2023, South Africa files a case before the International Court of Justice against Israel. And South Africa says, I know this is going to be upset to a lot of people, but A, we think that genocide is occurring in Gaza. And B, as a state party to the Genocide Convention, we have an obligation to do everything in our power to prevent genocide. We don't have the wherewithal to send the South African army or whatever intervene, but we're going to do this through law, right? And they file an action before the International Court of Justice, and the International Court just said yes, that South Africa can proceed with its case here. And then the third case I mentioned is in terms of torture. Then again in 2023, under the Torture Convention, Canada and the Netherlands filed an action against Syria saying that Syria is torturing. Essentially, Syria is torturing. Now, remember the graphic I put up before that 140 countries commit torture, right? So it's not like Syria is the only country that tortures. Syria is in very bad company. There's 139 other countries that do so. But the court said, yes, they are state parties to the Torture Convention and they can proceed with their case. So I did an article this summer that said, well, what do we say about countries that don't do anything? I mean, take a country like Paraguay. Paraguay, I'm sure, must be a state party to the Genocide Convention, right? Must be. Let's say they don't do anything, right? They don't do anything. They don't file an action against Myanmar. They don't bring an action against South Africa, against Israel. They don't do anything. Are they doing everything in their power to prevent genocide? I'm not convinced they are. They could be doing something because we know these other countries have done something. And then I thought, so I'm playing with, well, what do we say of them? They're not actually committing genocide themselves. They're not even aiding and assisting genocide, but they're not doing anything. And how do we categorize that? All right, the other thing I mentioned here is jurisdiction. This dirty little word, this is a bad word. This is a very bad word, jurisdiction here. So we have the European Convention, which Article 1 says the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in this convention. So what does it mean to be within the jurisdiction of a state? So the leading case here is this Bankovic case. So you have NATO forces that drop bombs on Serbia, 1999. They kill 18 people and they injure another 18. Serbia at that time is not a party to the European Convention. It is now, but at that time they're not. So the families of those deceased or the injured bring a case against the NATO forces minus the United States. And the court, to my mind, in a rather incredulous opinion, says, well, that the people who were injured or killed were not within the jurisdiction of the NATO forces. So think to yourself, wait a second, you've killed these people, right? You've killed these people or injured them. How do you say that they're not within the jurisdiction? And the court goes on later that if there were troops on the ground and they shot and killed somebody, that individual would be within your jurisdiction. Oh, okay. So if you shoot someone on the ground, they're within the jurisdiction. If you drop bombs from the air, they're not within the jurisdiction. And you begin to get these kind of silly things here. So I worked on this case, this Agostino case, with a group of lawyers from Amnesty International. And Agostino was a group of 16 Portuguese children who were claiming that they were within the jurisdiction not only of Portugal, because they live in Portugal. So they're on the territory of Portugal and they're within the jurisdiction of Portugal. But they also claim that they're within the jurisdiction of these other state parties because the greenhouse gas emissions from those countries was having a negative effect on them. Right? I think we're winning. I think we're winning. I'm celebrating before the judgment. We lose 16-0. All right? We lose 16-0. It said, no, they're not within the jurisdiction of these other countries. I think a much better interpretation is by the Inter-American Court of Human Rights that said you can be in this country here, but also within the jurisdiction of some other country if this other country is pursuing policies that have a negative effect on your well-being. I think the Inter-American Court, the American Convention, has a much better take on that. Foreign sovereign immunity. Don't get me started on foreign sovereign immunity, right? If foreign sovereign immunity were to disappear, I'd die a happy man, okay? So we have foreign sovereign immunity. Until the 1950s, states had absolute immunity. You could never sue another state in the domestic court of another country. Countries enjoyed absolute immunity. And then, well, they begin to involve themselves in commercial enterprises. Think of Alitalia, the state-owned Italian airliner. And then they begin to make some exceptions here. So the Al-Adsani case, let me just talk about this. Al-Adsani, European Court of Human Rights. A guy, al-Hassani, is a dual national of Kuwait and the UK. He goes to Kuwait to fight in the Persian Gulf War. He gets involved with some nasty business with the royal family. He's tortured. Okay? He comes back to the UK and he sues Kuwait. Right? He sues Kuwait. And the British courts all say, no, can't do so. Why? Because we have a law that says foreign sovereign immunity. You can't sue another state in British courts. He goes all the way to the High Court, can't do it. He then says, okay, bag this, I'm suing the United Kingdom for having a law that gives sovereign immunity to a country that commits torture. Oh, I'm liking this. 9-8 vote in the European Court of Human Rights, the same court that, by the way, defeated my team 16-0. 9-8, the court holds and said that the British sovereign immunity statute was consistent with the European Convention. In other words, it was not unlawful. Okay. 9-8, and I put up there, what a pity. I wrote an article because one of the dissenting judges begins his dissent with the term, what a pity. We had a moment where we could have fundamentally changed the whole nature of human rights. Because why? Because suddenly victims would have a place to go. They don't have a place to go. If you say that the British sovereign immunity statute is inconsistent with international law, what that means is that the British have to hear cases about human rights violations. And not only that, every other country that is a state party to the European Convention has to do likewise. To my mind, it could have fundamentally changed the nature of human rights. 9-8 vote. I mentioned Nelson versus Saudi Arabia, which is a U.S. Supreme Court case. This guy, Scott Nelson, Virginia Tech, graduates, goes to a job fair. The Saudi government says, hey, come work with us. You know, you make a lot of money. You can't drink, but you make a lot of money. He goes to Saudi Arabia and he's tortured. He comes back to the United States and he sues the Saudi government. U.S. Supreme Court says Saudi Arabia has foreign sovereign immunity. Under U.S. law, countries have sovereign immunity protection except, and I list these here, that if a country is involved in commercial activities in the United States, they don't have sovereign immunity protection. So the Supreme Court case was when they recruited Scott Nelson at the job fair in Virginia, were they engaged in a commercial activity? And the court ultimately declares, no, it did not. The expropriation of property, we're going to see this with Cuba, now that we're bringing Cuba to his knees in terms of that. The country doesn't get sovereign immunity protection. If there's a tortious act committed in the United States, in other words, if Scott Nelson had been tortured by Saudi agents in Virginia, they would not have sovereign immunity protection. And then the fourth exception is what's called the terrorism exception, that if a country has engaged in terrorism or provided material support for terrorism, they do not get sovereign immunity protection. Well, that sounds good, doesn't it? Let me give a little qualifiers here. One is that it's only for American nationals, and it's only if you are listed as a state sponsor of terrorism. Those four countries, and only those four countries, can be sued under the what is it called again? The State Sponsors of Terrorism Act. So if you get tortured in Cuba, you could sue the Cuban government. If you get tortured in Syria, you could sue the Syrian government. You get tortured in Saudi Arabia, no go. Saudi Arabia would have sovereign immunity protection. And as I said, there's no exception here for human rights exception. The head of state immunity. Head of state immunity. I get, and I put it on, this is like the divine rights of kings. The divine rights of kings. I mean, this means, this is a situation that says that one country in its domestic courts cannot proceed against a head of state of another country. Right, so the International Court of Justice case, again involving Belgium, and again why I'm fascinated with Belgium. Belgium, there was something like some guy was a transportation minister, right? Was not the head of the government. Transportation minister, there's a warrant, the Belgians have a warrant for his arrest, and the International Court of Justice says you can't do that, right? Because heads of state and their ministers have head of state immunity. I'm waiting, if I'm representing Maduro, this is the argument I'm making. Right? I'm making the argument that I'm head of state of Venezuela, and under international law, heads of state have immunity in the courts, in the domestic courts of other states. We'll see. I mean, I think most American judges, what they know about international law would fit on the back of most postage stamps. And you can quote me directly on that one, okay? And again, it's different from former heads of state. That was Pinochet. But the law is that heads of state get immunity. And then I thought we'd talk about the International Criminal Court for a second here. We have indictments against several leaders here. I was thinking there was a name missing on that list. I was trying to think. I was there, and it's at the tip of my tongue. I know there's a name missing from that. But this is the list. I mean, to my mind, 10 convictions since 2002. I don't know. I mean, to my mind, it's been disappointing. It's been disappointing. So here are some world leaders here like that. The United States, again, ambiguous. They signed the Rome Treaty, the Rome Statute, then George W. unsigns it. And then Trump has now taken vindictive action against the court itself, you know, taking away their computers or something like that, and all that. Well, let's talk about Camelot for a second. You remember Camelot, that one brief shining moment? Do you remember that? Well, we had one brief shining moment. It was when the Alien Tort Statute was actually showed some life. And the Alien Tort Statute is from the year 1789. One sentence statute, one sentence, right? It's the district court shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. No one knows, no one had ever heard of this. In 1980, you with me? In 1980, you have torture and killing in Paraguay. So you have a military dictatorship in Paraguay. There's a dissident, his son is tortured and killed. Is there justice in Paraguay? No justice in Paraguay. Okay. The torturer, the chief of police, Peña Arala, makes a trip to the United States. The decedent, also the sister of the decedent, lives in the United States. She files a claim against her brother's torturer and murderer, okay? Well, the judge says, what the hell is this doing in an American court, right? Everyone involved is Paraguayan. The events take place in Paraguay. I'm not sure why this case is before me, and the Center for Constitutional Rights says, well, look at the Alien Tort Statute from 1789 that no one had ever heard of. And the judges say, well, yeah, okay, this is a violation of international law. And then after that, there are almost literally hundreds of cases that are brought. What happens is you have to have a human rights violation, and you're bringing it against individuals. You're not bringing it against the state. The person has to be present in the United States. And finally, it's not a criminal case, it's a civil case. So in the Fee-Artiga case, the family, so they're told that they can proceed with their case. They get a default judgment, and the torturer, murderer goes back to Paraguay. So the family has a $13 million judgment against their son or brother's torture and murderer. It didn't seem to matter. I mean, finally, you have a place you can proceed and bring a claim for human rights violations. And that's why I call it Camelot. It's this one brief shining moment. By the year 2020, the U.S., particularly when cases were no longer filed against foreign nationals, but against the U.S. government and American corporations, the U.S. Supreme Court, boy, did they ever squelch that. And so at the present time, it's not even clear that there is anything to the Alien Tort Statute. All right, we got one or two more things, and then we'll go open this up for questions here. Oh, I almost got out of the penalty box here. Hold on a second. I just thought you'd be interested in ICE, right? I mean, think of it. International law promises every victim an effective remedy. Every single international treaty, many of which the United States is a party to, promises victims an effective treaty. So I thought we'd do what ICE is happening in Minnesota here. I don't know what to make of this. There was this quirk in American law that if a state trooper, a state agent, a state policeman commits a constitutional violation, that the victim can proceed against that person under what's called a 1983 action. In other words, there is a federal law that allows individuals to go against state officials who violate the constitutional rights of people, but there is no comparable statute for federal officials. So ICE is federal, right? ICE is federal official. So you have, if the killings had taken place and they were killed by state agents, people work for the Minnesota government, then they could proceed for violations of federal constitutional rights under 42 U.S.C. 1983. But again, there's nothing comparable in terms of federal officials. Well, then there's this little case, this case from 1971, where the court says, well, we're going to make an exception. Yes, we're going to make an exception. This is called a Bivens-style remedy, based on this case from 1971. These guys go in, drug bust, they got the wrong house. Right? They're pistol whipping people, they got the wrong house. And so the victims here bring a case against these 6 unnamed federal agents, and the court creates an exception. But the problem is that the exceptions never broaden into a bigger rule. Pretty much courts that hear cases that attempt to get this Bivens-style remedy say, well, it's not a drug bust, right? I mean, the people that were shot in Minnesota, it wasn't a drug bust, and if Congress wants to extend a Bivens-style remedy, then Congress can do so, but Congress hasn't. We're not going to create a new cause of action. The states themselves can create a cause of action, so you'd be suing a federal official under state law. But that hasn't happened. None of the 50 states have that. So one reason I think that the guys from ICE will escape justice here, escape accountability, is because of this missing link here of not having a cause of action against a federal official. This is our last slide, ladies and gentlemen. You've been very patient. You've been very patient here. So what's to be done? We always add with these, it's like these documentaries, what you can do and stuff like that. But what can be done? Well, I still, as I said at the beginning, I think our conceptualization of human rights is wrong-headed. I really do. I think the basic problem here is how we conceptualize human rights. We conceptualize it is that each state is signing on to these international treaties, and their only concern is within the territory of that state. My answer has been, why would you join the Torture Convention? Why would you sign and ratify this international treaty if the only thing you were worried about was torture within the territory of that state? Right? To my mind, that makes no sense. The whole point of international human rights treaties is that this is a collective effort here. right? This is a collective effort. We all have to do our part. And you saw some indications of the recognition of that, right? I think with the genocide, the South Africa, Gambia, the torture with Canada and the Netherlands, but for the most part, I don't think states have been able to conceive of human rights as something that they have obligations beyond their own territory. I think that's one of the first problems here. Second thing I mentioned is that states have this obligation to prevent human rights violations no matter where they occur. And of course, they're going to be much more able to do that within their own territory, right? They should be able to do so. But that doesn't mean that they don't have any obligations outside their territory. I mean, again, go back to that example with state responsibility. They're sending weapons, they're sending torture things, they're training, they're providing intelligence and all this kind of stuff here. That should not be lawful, in my mind. These states are aiding and assisting in state B's torture. And there should be some way that we could hold state A accountable for doing so. The foreign sovereign immunity, as I said, I'd be a happy man if just this was happening. And I won't even eliminate it altogether. Right, use Kogan's is a term in international law. This is like the most serious violations. You say, what's a use Kogan's violation? Well, the two that are agreed upon are genocide and torture. Everyone agrees that this is a special category of violation, right? Genocide and torture. So I think if a country is accused of committing genocide or torture, then the victims should be able to bring a case against them in a domestic court in another country. And again, for the torture victim, if you've been tortured by a state, you'd be foolish to bring a case in that country, right? If I'm tortured by the Paraguayan government, I don't think I'm going to bring a case against Paraguay, right? They've already tortured me. I don't need another episode of torture. So I think states that commit use Kogan's norms violations should not have sovereign immunity protection. We've got two more here. Head of state immunity, I don't get it. And again, I would make exceptions for use Kogan's. That if, I tell my students that when I used to give talks against the death penalty, then the question I was always asked, because I'd oppose the death penalty. The first question I was always asked, what about Hitler? What about Hitler? Do you mean to tell me that you wouldn't, okay. But I think in terms of head of state immunity, I'll use that same example. What about Hitler? If Hitler were, happened to go to Mexico, he's head of state, you can't prosecute this guy because, you can play this game too. I don't see it for heads of state that commit use Kogan's violations here. And then a little policy that I had, I wrote a short piece in 2002. I said I wasn't confident of the International Criminal Court, and my lack of confidence has been reaffirmed. It really has been. What I called for in the article was the creation of an international civil court, a court where victims could go, right? Where victims could go and press their claim against the state that has violated their human rights. And so in my example of state A and B, you'd be able to sue state B, but you would also be suing state A because it's providing this kind of stuff. Anyway, let me end that. Let me take some questions from the audience here. Thank you very much.
Talk straight into it. This is great. I've got 100 questions.
Oh, good. All right, I got all night.
I'll just
and I'm charging by the hour, though. Go ahead. What do you got?
I'll just give you the one that comes immediately to mind.
Okay.
Sometime in 2003 or 4, Congress voted that Sudan was committing genocide. And my understanding at the time was that created an obligation on the country that declared it such
Yeah.
to do something about it.
Yeah.
Could you tell a little bit about that? Sort of
Yeah,
thing?
yeah, and nothing happened, did it? No, you're right. You are right, though, that Congress did say that Sudan was engaged in genocide. There was a UN commission that said that there was not genocide. Let me take, because I've been asked a lot about Gaza. Is Gaza genocide or not? I've been asked that endlessly. I'm not trying to avoid the question, but what I don't want to engage in is that there's just something about genocide that is so separate and distinct from gross and systematic human rights violations, right? I mean, genocide is this intent to destroy in whole or in part. So I don't usually get caught up in, is it genocide or not? But as you point out, if it is genocide, then all the state parties have to do everything in their power to prevent it. And if it's not genocide, does that mean they don't have to do anything? It's that dichotomy that I simply refuse to engage in, right? If it's genocide, we got to do everything in our power, even though, as you point out, they don't do anything. But if it's not genocide, well, then we don't have to do anything. I don't want to live in that world, right? I don't want to live in that world. Who else? So you got another question? Yeah, here?
You got more questions?
More? No, okay.
All right. I was trying to come up how to phrase this in a question. In 1979, I was in the middle of college, and the Shah of Iran came to America.
Yeah.
And I remember all this stuff. You remember?
Yeah.
So I wanted to get your opinion on it. I mean, he didn't go back because a regime change happened, and we were punished. I mean, the United States was punished with all the stuff that went on. So I wanted to get your opinion about that.
Yeah. I mean, we're going down memory lane, aren't we? Yeah, we're going down memory lane because in 79, remember he comes to the United States for medical treatment. That's why he came. It wasn't, and there was sort of this warning that if he comes to the United States, that this is going to set off an explosion in Iran. I don't think anyone anticipated the U.S. Embassy, the 444 days of, you recall, Walter Cronkite would begin every day. This is day 193 of the, right, and it seems like we're kind of going full circle, doesn't it? It does seem like that. It does seem like that. I was talking to one of my students in my office today and said that the Shah's son is in the bullpen warming up, right? The Shah's son is David Unifor. The Shah's son is warming up because he wants to be installed again. And this student said to me, not one of my students back there, said, "Oh, that won't happen." I said, "Well, I wouldn't be shocked by that, because if they think this is a guy they could do business with, and that's all that's important is to do business with them, then I could see them doing something, some dumbass thing like that. I could actually see that as well." So, yeah, but maybe we're just those who are, something about history repeating itself like that. Who else has some questions here? Yeah, David, go ahead. Need the microphone. Yeah. Oh, here we go. Jay, go ahead.
Since countries have the ability to refuse to sign on, and even internally refuse to ratify it, how do countries who do subscribe to those treaties cope with that if there's a genocide happening in a country that...
Oh, yeah. I mean, listen, it's that countries just decide we're not going to become a state party. And I think one of the examples I use is the Convention on the Rights of the Child. Every single country in the world, except for the United States, is a state party. And when I looked at it, I didn't realize the United States had signed it but hasn't ratified it. That doesn't mean that children in the United States don't have human rights, even though they really don't, between the two of us. But that means that the United States will protect their human rights through domestic measures. So I'm less bothered by it than many other human rights types who are, the United States has to, to my mind, a lot of these states just signed and ratified everything. All right, think of all the countries that signed and ratified the Torture Convention with full intent of continuing their torturous practices here. I don't know. I mean, I was going to call it a sham. Let me tell you a good day and a bad day. Okay, a good day is I actually think that these treaties and human rights law mean something. That's a good day. You know what a bad day is? A bad day is I think to myself, I'm not sure the world would look that much different if we didn't have any of these things. I'm not convinced. You know, that's a bad day. And I try to fight the bad days with the good days. I try to find, like I did with the Netherlands and Canada bringing, I try to look for situations where countries seem to recognize the universality of human rights and see their obligations as extending outward beyond their own territory. But you're right, they don't have to sign, they don't have to, the problem has not been countries don't sign and ratify. The problem is they sign, they ratify, and then they just go ahead and do whatever the hell they want. That's the problem, I think. Who else has got some? Go ahead, David. Yeah.
The Camelot case, you said there was a $13 million judgment.
Yeah.
Was it paid?
No. No, it's not, in fact, there were a whole series of judgments. 13 was small. Many of them ran into hundreds of millions. Hundreds of millions. Default judgments, default judgments, default judgments. Never a single cent passed hands. When the Marcos, remember the Marcos regime in the Philippines, when there was a new government, they said, because someone had brought an alien tort statute case against Fernando Marcos and maybe his wife, $500 million, billion, whatever it was. It was a big judgment. The new government says, we will honor that judgment, but they never did. And so all you had was really a series of symbolic victories. Someday when we go out for a beer, I'll tell you a case I worked on about the Pan Am Games, but that's too long a story. Yeah. Other questions here? Yeah. We got a microphone? Larry, I think you're not being the attentive husband here. I think.
What does it really mean for a state to do everything in its power?
Yeah.
Stop genocide. Does it mean taking military action?
No, everything's on the table.
But does it mean stopping any kind of trade with another nation? What does it mean?
I don't know. I'm with you. I mean, I love the legal standard. I love the fact that in the International Court of Justice uses such strong language of everything in their power. But I'm with you on that. I don't know what it means. I don't know what it means. It would seem to mean all of the above. You don't send weapons there. You don't trade with those people. You file an action. Maybe you even introduce soldiers to serve as a barrier or something like that. That part has not been determined what everything in your power to prevent means. And I'm with you. I think maybe we should write an article together. You come up with, hey, well, they ought to do X, Y, and Z, and I'm sure I would agree with you. I think I take everything to mean everything. Yeah. Other questions here? No?
Has Ukraine bought has Ukraine bought any cases against Russia as a result of this?
Yeah, no, that's been a mess. That's been a mess. The day after the Russian invasion, Ukraine sued Russia. Russia then sued the Ukraine. The Russians sued the Ukraine what I'm about to say you're hearing correctly, that the Russians claimed that the Ukraine was committing genocide against the Russians in the eastern part of the Ukraine. And the International Court of Justice has just been putzing around with this case, has allowed both cases to go forward. International law is not pretty. I mean, you may say to yourself, Mark, you seem to like all this legal stuff, but at the end of the day, what has it amounted to? Right? South Africa brings a case against Israel. They get some provisional measures, but it will take years before you get a final judgment, when people won't even remember Gaza. And I think the same thing with the Ukraine and Russia, which is that Yeah, it's kind of the lawyers are just filing briefs and filing this and this and the next thing. So with that, George, we have one of my more brilliant students right here who's got a question.
Mark, I have a question.
Yeah, please. Oh, sorry, Dot. Go ahead.
What happened with the Gambia and Myanmar?
Oh, yeah. So the Gambia and Myanmar, well, the court said that Gambia could proceed. I mean, the argument of Myanmar was the International Court of Justice should just dismiss this case because the Gambia has nothing to do with Myanmar politics. Right, but they didn't say that. What the International Court of Justice said, yes, that Gambia is a state party, and Janie pointing out, they have to do everything in their power to prevent. And they're not about to send Gambian troops to Myanmar. The way they have said we'll meet our obligations is to file a legal claim.
Is it still up in?
Yeah. So, and they'll have a decision. I'll be dead by then, but they'll have a decision in 2047 or something like that. But it still is. But I think the more important point is for the International Court of Justice to say they're an interested party. They're an interested party. They can proceed. And again, the question I ask is, what about the other states that didn't do anything? What do we say about them? I mean, they could do something. They could just sign on with Gambia. Oh, add our country to your petition before the International Court of Justice. Add our country as well. Some countries did do that, particularly with South Africa and Israel. The number of countries that joined the petition was fairly substantial. Maybe a quarter of the countries of the world joined with the South African petition. Fewer countries joined with the Gambia case here. Micah, go ahead.
So I was wondering, when it comes to like state responsibility in countries not taking action against other state parties, do you think it comes from like not wanting to rock the boat, whether it be for their own interest or reputation, or if it is more so like the torture convention, where there's so many countries that are engaging in torture that it's like, where do you even start with that?
I'm not sure what that's what I'm saying. I'm not sure if the problem is international law. I'm not sure if it's the state's interpretation of international law or a combination of the two. But I think most countries, I mean, I can go to conferences and get up on the soapbox in class and other places, but I don't, and I understand why states think, well, I mean, what is genocide in Myanmar? What is that to us? Maybe if we were one of the neighboring countries and we're getting refugees from Myanmar, but it doesn't affect us. And I think that's what it is. I think for many countries they think whatever's happening here does not affect us. It's not in our national interest to involve ourselves with this. And that seems to be the way that states have operated. It's not in our self-interest, our national interest to. This thing is tight as hell. I mean, my head look like it's about to explode or anything? No. Okay. But that's why I think that they do that. I do. Yeah, please.
Could citizens of our own country sue our country for what our country's doing to Cuba?
Man, now you're talking like a lawyer here. Yes, they could. Yes, they could, but I'll tell you what would happen. That courts would just say that this is involving with foreign affairs, that the judiciary is not well placed to deal with matters of foreign affairs, and dismiss the case. Because there were a number of cases in the 1980s about U.S. policy in Central America. Number of cases, all of them were just sort of like sideline dismissed. We're judges. What do we know about American foreign policy? Punto. Just showing a little Spanish there, right? They do that. Yeah, please.
So, with respect to the problem perhaps being international law.
Let me take this off and just behind this thing. I mean, my head is.
You can just hold it up to your mouth.
Yeah, I guess so. I talk. Yeah, go ahead.
So, where does in what fields, in what areas does international law work? Obviously, it works in some areas.
Yeah,
now,
yeah.
for those of us who know nothing about international
Yeah.
law, which is me,
Yeah.
there must be some. So the question would be, why does it work in
Yeah.
A, B, and C? It doesn't work here
I
in
agree.
D.
Because it does work, right? I mean, if you're gonna send a letter, you're gonna send a letter to a friend in Tanzania. There's governing things. It's all governed by international law, international agreements. When you're going to take a flight to, give me a place. Let's say you want to go to Slovenia. You're going to be flying over various countries. Do you think that that the plane has to get permission from each of the countries to go over their airspace? No, that's been solved by international law. There's international treaties. But exactly, you're right. There are most of the time international law works. We don't even know it works. We just assume we can fly from here to Slovenia, or we can send a letter to Tanzania and it would arrive. It's when it doesn't work, and when it doesn't work. But I would also say that domestic law oftentimes doesn't work. I used to use the example of speeding on the highway. You think anyone's ever? But here's a better example. That you know, remember when I had that graphic about the Arms Trade Treaty, the United States seemed in it and not in it. But under domestic law, under federal domestic law, the United States is not to sell weapons to a country, under domestic law, to a country that violates human rights standards. The United States provided a lot of weapons to Israel during the conflict in Gaza. So you would say, well, that's a failure of international law. But to my mind, it's also a failure of domestic law as well. But I guess what I'd say to you is that the successes of international law are usually not things that are obvious. It's the failures that I think we do that. Back to you.
But there are things that are important enough for the law to actually work. That's the point. So
Yeah.
why is this most important of areas not working? It's because of the lack of something.
Yeah, it's the lack of something, and I'm not sure what that something is. I'm not sure.
Consequences.
See, to my mind, it's a lack of accountability, just generally. I mean, I think there's a lack of accountability, and again, I think it's the example I use because it's simple: state A and state B. But A is never going to be held accountable, and probably state B will never be held accountable either. So state B's torturing with impunity. They're not going to face any kind of consequences. State A is providing torture equipment and training and intelligence. They're not going to face any kind of consequences. And that's why I was saying, to my mind, that case, that Al-Adsani case was so important, the one I said was 9-8 vote. Because to my mind, for the very first time, there would be consequences. There would be consequences, because if the court had said that the UK cannot provide sovereign immunity protection to a country, Kuwait, that violates the torture convention, then that means that torture victims will have a place to go, which is they can go to the UK and all the other state parties to the European Convention, all, I think it's 46 countries. To my mind, why that's a game changer is that for the first time you would have a place to go. And you would say, okay, so if you go, maybe you get one of these default judgments. Maybe. But the Alien Tort Statute cases were against individuals. Against individuals. If you sue a state, all right, let's say you sued, let's say the Nelson case, Scott Nelson sues Saudi Arabia. And let's say he's able to proceed with his claim. Do you think Saudi Arabia doesn't have assets in the United States? It has a lot of assets. This is the way law works. You get a judgment or default judgment, and you execute on the judgment. Now, I know what I'm saying here sounds like you're thinking, Mark, do you live in an insane asylum? Right? I mean, I know that. This doesn't sound, but that's why I also say I think this is a failure of imagination. I actually do think that there are tools out there. Right? I think there's tools out there. I mean, even like that Fiortiga case. The judge's first reaction is, why this case before me? I mean, everything happens in Paraguay. The actors are all Paraguayan. Why is this case in New York City before me as a federal judge? Oh, I see, there's this 1789 stat, whatever here. So I think that's, but to pinpoint the one thing that's the problem, I'm not so sure, but I do think it's accountability, the lack of accountability, and that along with the failure of imagination. I'll go with those two. Other questions here, comments here, please. This is question number 7 for you. Okay.
Any comments about the handling of the people brought to Guantanamo Bay with American law?
Yeah, about the enemy combatants held on Guantanamo?
Right, and the torture down there.
Yeah, well, I'll tell you this, though. I thought one of the Supreme Court's shining moments was in the 2000s, because remember there was they had the enemy combatants that were being held in Guantanamo Bay, and there was a habeas corpus petition by a group of them. And I tell my students, I said, I was positive that the case would be dismissed on the basis of this is foreign affairs, we don't know anything about the war on terror, all these kind of excuses that they would have. And the shocking thing to me was that the Supreme Court in the Rasul case 2004, well, there were 3 cases. The Hamdan case 2 years later, and the Boumediene case, the court said, no, we're gonna decide this, and said that ultimately that these people, foreign nationals, had constitutional rights, had rights under the American Constitution to some kind of fair hearing. And I thought that was a moment that I was not expecting, because I was expecting the court to just simply, and certainly the Bush administration was saying, dismiss the case, you don't know the first thing about the war on terror, but the court, I think, acquitted itself well on that. I do, yeah. We have any more questions here? Any comments?
Sort of trivial question.
Yeah.
Why did Gambia do that?
I don't know. Why did Belgium? I have Belgian colleagues. I say, we ought to write an article. Why is Belgium all of a sudden deciding, is it their colonial past? Is it King Leopold? I don't know. I don't know why. I have no idea why Gambia did what it did. No, I don't know. I don't know. We'll have to take a trip there. We'll have to go see the foreign minister. I don't know why they did. I'm very pleased they did, and I'm very pleased that the International Court of Justice said yes, they have an obligation to prevent, and that's what they're doing here. Please, yeah.
So I'm curious about the difference between proving genocide and crimes against humanity. Is one a lot more difficult than the other and take a lot more effort?
I don't know if it's effort. It's you've got to prove this so-called genocidal intent. And when I mentioned before about the Sudan, right? The Congress, you're right. This Congress said that it was genocide. This commission by the United Nations said it was not genocide, and the UN Commission said, well, when the Janjaweed, which was supported by the Sudanese government, when they would go into villages, they wouldn't they wouldn't kill everybody. And on that basis, they thought that there was no intent to destroy in whole or in part. Again, I think we're getting into semantics oftentimes. It's not the number, but you also know that there's something about the G word. There's something about the G word that all of us look like we're kind of starstruck. Okay, I mean, genocide's horrible, but so are gross and systematic human rights violations and war crimes and things of that sort. That's horrible as well. I'd say that, yeah. Shall we call it a night? Shall we call it a night? All right, thank you very much. I want to thank you for putting up with me.